Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments and significant rulings from the world of law. We will begin with the headlines and a concise overview of the top stories, and after that we will delve into the full details. A plea has been filed in the Supreme Court challenging Rajasthan Civil Judge Cadre Exam 2024 results, seeking evaluation by an independent expert committee. The Supreme Court has dismissed Azam Khan Trust's plea against Uttar Pradesh government's cancelling the lease. The Supreme Court has said that no matter how strict PMLA is, sick and infirm accused should be given bail. The top court has dismissed a plea for Doordarshan channel in Sindhi. The Supreme Court has refused to entertain a plea to restrain Jammu and Kashmir LG from nominating members to the Assembly. It has asked the petitioner to approach the High Court. The Apex Court has dismissed a plea alleging vaccine side effects, saying that because of COVID vaccines, we are able to deal with the outbreak. Supreme Court has refused to entertain the plea to criminalize sexual offences against men, trans persons and animals in Bharatiya Nyaya Sanhita. The Delhi High Court has observed that Anganwadi workers can earn from other sources as recompense from Anganwadi work is meagre. The top court has upheld dismissal of defamation suit against an advocate, saying that lawyers' statement during judicial proceedings are protected by privilege. The top court is likely to hear soon the pending challenge to marital rape exception under the definition of offence of rape in the criminal laws. A writ petition has been filed in the Supreme Court challenging the Rajasthan Civil Judge Cadre 2024 exam on the ground that its evaluation process was arbitrary and flawed. The petition has been filed by 96 candidates who undertook the exam. The Rajasthan High Court, in compliance with Rajasthan Judicial Services Rules 2010, opened 222 vacancies for direct recruitment to the Civil Judge Cadre. The selection process follows a three-stage process: a preliminary examination, a mains exam and an interview. Out of approximately 3,000 candidates who qualified for the main examination held on 31st August and 1st September this year, only 638 candidates progressed to the interview stage. The candidates allege that after the results of mains examination were released, their scorecards revealed extremely low marks between 0 and 15, specifically in the English essay paper. This irregular scoring contrasts with their otherwise strong performances, leaving the petitioners unable to reach the interview cutoff. The petitioners argue that the subjective evaluation of essay writing combined with no minimum qualifying mark for language papers has led to arbitrary results affecting their fundamental rights and careers. They urge the Supreme Court to mandate an independent review in this case and to ensure an impartial re-evaluation of their answer sheets by an independent expert committee. The petition was today mentioned before the Chief Justice of India, D.Y. Chandrachud, for urgent listing as the interviews are going to commence on 16th October. The CJI agreed to list the matter soon. The Supreme Court today refused to interfere with the Uttar Pradesh government's decision to cancel the lease of government land to Maulana Muhammad Ali Jauhar Trust at Rampur. A bench comprising CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra dismissed the petition filed by the trust, founded by Samajwadi Party leader Azam Khan, challenging the cancellation of the lease deed. The trust approached the Supreme Court against the Allahabad High Court's judgment delivered in March this year, which had dismissed its plea against the government's decision to cancel the lease taken in March 2023. Senior advocate Kapil Sibal, representing the trust in the Supreme Court, argued that the decision to grant the lease was made without any explanation. Senior advocate Kapil Sibal, representing the trust, argued that the decision to revoke the lease was made without any explanation. However, Chief Justice Chandrachud raised concerns about the lease's validity, noting that in 2015, when Azam Khan was a minister, the land was allotted to a private trust of which Khan is a lifetime member. The CJI questioned how land meant for a government institute could be leased to a private trust. When Sibal argued that the petitioner had not been given proper notice, the Chief Justice responded that the facts of the case clearly showed a misuse of office. He added that when the facts are so clear, the lack of proper notice may not be a significant issue. The bench dismissed the petition, saying that there is no infirmity in the High Court's judgment. However, the bench requested the government authorities to ensure that the students of the school, which was functioning in the land leased to the trust, get admission to alternate suitable institutions. Observing that sick and infirm persons can be granted bail despite the stringency of Prevention of Money Laundering Act, the Supreme Court today granted interim bail to Amar Sadhuram Mulchandani, who is the former chairperson of Seva Vikas Cooperative Bank and is accused of the offence of money laundering. Senior advocate Mukul Rohtagi for the petitioner submitted that Mulchandani was suffering from chronic kidney disease and could not perform daily activities while being incarcerated. He stressed that the accused was aged 67 years and had been in jail for 1 year and 3 months now and has not been named in any predicate offence. Senior advocate Atmaram Nadkarni opposed the grant of bail by saying that the accused was facing other FIRs for tampering with the evidence. He suggested that the accused could be admitted to a nearby hospital under custody. The bench led by CJI Chandrachud perused the medical reports furnished by 4-member expert committee of the JJ group of hospitals before granting the relief. It said that even though the PMLA is strict, the court must follow the law. The CJI, referring to Section 45 of PMLA, explained that the law says that an accused who is sick or infirm can be granted bail regardless of the twin conditions specified for grant of bail. He also added that the argument that a person can be treated in a government hospital does not meet the law's requirements. In the next update, the Supreme Court has today dismissed a petition seeking to direct the Union government and the Prasar Bharati to run a 24-hour Sindhi language Doordarshan TV channel to preserve the language and cultural heritage of the Sindhi community, which is a linguistic minority in India. The petitioner Sindhi Sangat approached the Supreme Court after the Delhi High Court dismissed the plea for start of a separate language channel. Senior advocate Indira Jaisingh, representing the petitioner, challenged the criteria used by respondents for starting DD language channels which are based on territory. She explained that DD broadcasts programs in the main language of the region where the station is located. Jaisingh argued that these criteria do not meet the reasonableness standards set by Wensbury principles, especially since the Sindhi population does not have a state of their own. She pointed out that Sindhis are a refugee community spread across the country, making a rigid policy regarding the Sindhi language unreasonable. However, the CJI pointed out that before the High Court, the petitioner had not challenged the DD's policy and the prayer was only to start a separate channel. The court expressed reluctance to entertain the plea, saying that it was a policy matter. The court highlighted the statement made by Doordarshan before the High Court that it was running Sindhi programs in 3 DD channels which are aired in areas where Sindhi population are predominantly located. The CJI also referred to Doordarshan's stand that a separate channel catering to a small population of about 26 lakhs was not sustainable given the annual running cost of approximately 20 crores. The court dismissed the petition, observing that no citizen can make a claim based on fundamental right guaranteed under Article 29 of the Constitution that the government should start a separate channel in their language. The top court today declined to entertain a petition challenging the Jammu and Kashmir Lieutenant Governor's proposal to nominate 5 members to the J&K Assembly. As per the J&K Reorganization Act of 2019, 90 seats are reserved for Jammu and Kashmir divisions and 5 are those to which LG can nominate MLAs. In the recently held elections to the 90 seats in J&K, the NC Congress Alliance won 48 seats. Senior advocate Dr. Abhishek Manu Singhvi, representing the petitioner Ravindra Kumar Sharma, argued that this issue is fundamental to the Constitution. He explained that if the government nominates members beyond the 90 assembly seats, it could disrupt the balance of power. He pointed out that Alliance has 40 seats, which is 3 more than the majority, while the other parties have 42. If 5 additional nominees are appointed, increased from 2, the total for the alliance would be 47, making it easier for them to gain control. Singhvi warned that this could undermine the elected mandate, as nominees could override the decisions made by elected representatives. He expressed concern that if the nominations increase to 10 in the future through amendments, it would further dilute the electoral verdict. The bench comprising Justices Sanjeev Khanna and Sanjay Kumar stated that the nomination power had not yet been exercised, suggesting that the petitioner should approach the High Court first. The bench said that it would not express an opinion on the merits of the case. The top court has today dismissed a PIL alleging health side effects to the COVID vaccines. The counsel for the petitioners stated that allegedly the vaccines induced side effects like blood clotting. He mentioned that class action suits have been filed in foreign countries like the United Kingdom on the same concerns. However, the bench led by CJI D.Y. Chandrachud stressed that vaccines had globally aided in overcoming the pandemic crisis and that filing such petitions now would not be appropriate. The CJI said that if the petitioners were really aggrieved, then they should file class action suits instead of filing Article 32 petitions. Justice Pardiwala interjected to ask if the petitioner suffered from any side effects personally after taking the vaccine, to which the counsel replied in negative. The court refused to entertain the petition any further. Let me tell you here that British pharma company AstraZeneca is facing a legal suit by 51 petitioners before the UK High Court, claiming fatalities and severe injuries as a result of the vaccine. During the proceedings, the company admitted that the COVID vaccine may cause a condition named thrombosis with TTS in rare scenarios. AstraZeneca had developed the vaccines including Covishield, which was manufactured by the Serum Institute of India. The top court today refused to entertain another PIL seeking directions under Article 142 to introduce sexual offences against men, trans persons and animals under the newly enacted Bharatiya Nyaya Sanhita, which replaced the IPC. The petition was filed contending that the new BNS omitted the former Section 377 of the IPC, which criminalized unnatural sex and carnal intercourse with a man, woman or animal. You are aware that the provision was struck down in the landmark decision of Navtej Singh Jauhar versus Union of India by the Apex Court so far as it criminalized consensual sexual acts of adults. But non-consensual homosexual acts were punishable as per Section 377. Presently, the BNS does not contain any provision criminalizing sexual offences against men, trans persons and animals. The counsel for the petitioner here relied upon the decision of the top court in P. Ramchandra Rao versus State of Karnataka, where it was observed that in the presence of lacuna in law, the court can pass suitable guidelines. The top court, however, observed that it cannot direct the parliament to create an offence, as such exercise falls under parliamentary domain. However, the bench permitted the petitioner to make legal representation before the Union of India. In an important update, the Delhi High Court has ruled that Anganwadi workers can earn additional income alongside their Anganwadi jobs, acknowledging that their salaries are often insufficient to support themselves and their families. In this case, an Anganwadi worker applied for the position of supervisor grade 2 but had her application rejected due to being overage and issues with her experience certificates. The worker claimed to have worked at both the Anganwadi and an NGO simultaneously, arguing that the nature of her work allowed for such arrangements. The Central Administrative Tribunal sided with her, confirming her certificates and granting her age relaxation for the position. The Delhi Subordinate Services Selection Board challenged this decision of the tribunal in the High Court, arguing that the worker could not have held both positions at the same time. But the court noted that selection board had not contested her experience as an Anganwadi worker and found no issue with the certificates. Additionally, the court held that the remuneration received by Anganwadi workers is meager and the workers often struggle to sustain themselves or their families. Therefore, it would be unjust for them to offer their services full-time even after the Anganwadi work is over. The court held that it is justified if the Anganwadi workers take up some more work in order to have an additional income apart from what they are paid from the Anganwadi work. With this, the bench of Justices Harish Shankar and Sudhir Kumar Jain upheld the order of the tribunal and dismissed the writ petition. In another update, the Supreme Court today upheld dismissal of a defamation suit against senior advocate Vikas Pahwa for a statement he made during judicial proceedings at Patiala House Courts in Delhi based on the instructions of the Briefing Council. A bench of Justices Dipankar Datta and Sadeep Mehta of the Supreme Court ruled in favor of Pahwa, agreeing with the Delhi High Court's decision that his statement was protected by the doctrine of absolute privilege. This doctrine, let me tell you, shields statements made in the course of judicial proceedings from defamation claims. Pahwa represented the complainant Pankaj Oswal's mother in a criminal revision hearing where, on instructions, he informed the court that mediation was not feasible due to Pankaj Oswal's use of unparliamentary language and abusive behavior towards his mother during previous mediation sessions. Pankaj Oswal objected to this statement and subsequently filed a defamation suit against Pahwa before the Delhi High Court. The High Court proceeded to dismiss the suit. Pankaj Oswal challenged this, contending that lawyers do not enjoy absolute immunity when their statements infringe upon an individual's right to reputation, which is a fundamental right protected under Article 21 of the Constitution. Pahwa argued that the defamation suit against him was baseless for several reasons. Advocates are protected by absolute privileges when making statements in court, which helps to keep the justice system running smoothly. He stated that his comments were made following instructions from his counsel, so there was no malice involved. He also described the suit as frivolous attempt to disrupt his legal work for Pankaj Oswal's mother and pointed out that the supposed defamatory statement was not recorded in the court's documents, weakening Oswal's case. The top court upheld the High Court's order of dismissal. And lastly, the Supreme Court is likely to hear soon the pending challenge to marital rape exception under the definition of offence of rape in the criminal laws. Notably, Section 63 of Bharatiya Nyaya Sanhita and the former Section 375 of IPC exclude non-consensual sex between a married man and his wife from the definition of rape. The bench led by CJI D.Y. Chandrachud is seized of the constitutional validity of the exception as well as Section 9 of the Hindu Marriage Act, which relates to restitution of conjugal rights. The union in its recent affidavit opposed the court criminalized marital rape. The union stated that alternative remedies in law already exist to protect married women against sexual violence, and attracting the offence of rape to the institution of marriage may be excessively harsh and disproportionate. The centre claims that to decide the matter, a holistic approach is required to be taken after due consultation with all the states. It added that the issue raised before the court presently is more social than legal, and criminalization of marital rape falls within the ambit of legislative policy. The Chief Justice today said that the marital rape matter would be heard soon. Stay tuned. For more information on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe to our channel. You can support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.